Hello, everyone. Thank you for joining us today. My name is Mark Haskelson. I'm president of Compliance Group. I'm very honored to be doing a HIPAA 101, the 30-minute guide to understanding compliance. Today's webinar is sponsored by Novastore. We are particularly impressed with their technology. You know, the issues that the SMB or the small and mid-sized community is dealing with backup and storage is a tough one. And knowing folks like Novastore out there that are offering extremely cost-effective and best-of-breed solutions, we think is a very important differentiator. So for today, we're going to be spending, we'll probably more like 45 minutes to an hour, because we also have Novastore is going to be talking a little bit about some backup and storage issues that we think are critical to your compliance. If you are interested, there's lots of other free content like this. If you go to a compliance group, there's a whole education series, webinars like we're doing today with Novastore, as well as other information in regards to the small and mid-sized organizations across the U.S. and how they can deal with compliance. There's lots of other free resources, so please do so. As far as questions today, we do welcome questions. We have a lot of material to cover, so what we're going to do is we're going to save the questions to the end. You're welcome to post them, throughout the webinar, but we're going to save answering them until the end so we don't run out of time. If by chance we do not get a chance to answer your question, one of us, either Novastore or Compliance Group, will respond back to you in the next 24 to 48 hours with whatever question you posted. So, with no further ado, let us get started. First of all, I'm Mark Haskelson. That's the picture of my mug. And then for what will be the second half of the webinar, it'll be Mike Andrews, the Managing Director of Novastore. Please, if you do have questions, our emails are up, and you are welcome to post us, reach out to either one of us after the webinar, and we'll do our best to answer your questions. So, real quick, just so that as we're going through this, you can feel confident that the information I'm sharing with you is not just some dry data. Compliance Group is one of the leaders in providing what is HIPAA compliance tracking solutions to the market. We have tens of thousands of clients across the country. Our clients never fail audits. They're very happy. That's great. What's more important is we really are endorsed by the majority of the healthcare community, both on the technology side as well as the end user side. So you see folks, many of the medical associations, the EHRs you work with, the security technologies you might be interacting with, are folks that we work with on a regular basis. So with that as a background, what I am going to be talking about today is not going to be dry HIPAA. Okay, it's going to be real world examples, specifically where we see misunderstandings. Okay, because what happens is we often see people doing a lot of things right with compliance, but missing some of the critical elements that are the things that are going to prevent you from getting fines. So along those veins, as we get started here, I'm going to play a little game. And if we were live in a room together, I would ask you to raise your hands, but we're not, right? So in this case, often what we see when we're talking to people, that what they believe to make them HIPAA compliant, for example, often folks will say we don't need to worry about HIPAA compliance. We've had a security risk assessment done by our IT firm. Okay, that's fantastic. Next thing we often see is people who will say, I've purchased a manual, I have policies and procedures, therefore, I believe I have addressed the minimum requirements of HIPAA. And then the last thing we see is people will say, we've addressed training. Okay, and that we've invested in either computer-based training or maybe on-site training courses, all of which is fantastic, except the problem is these are the three things you've done in regards to compliance. You're not HIPAA compliant, okay, and you would absolutely fail an audit. So the example that I'm going to use here is there was an Alaskan nonprofit, not a particularly large firm. They were fined $150,000, a minor malware issue, so it was a virus that was downloaded. In their case, they were fined, even though they had audits, i.e. they had a security risk assessment, but not the other audits that are required, which I'll talk more about. They had policies and procedures, and although store-bought or let's say manual type policies and procedures can be correct, in this particular case, they were never updated or modified to reflect the way the organization ran, nor were they updated every year, which is a requirement. And then lastly, their training, although a perfectly competent HIPAA training, the problem from the auditor's perspective was it was done once a year. And in this particular case, the Alaska Behavioral Health Group, they had about a 30% turnover, which meant about a third, technically a third of their firm could have gone a year or more without being HIPAA compliant. Okay, so let's get into more of what we see. So often people are doing pieces of compliance well. They'll do security risk assessments, but there's actually 6 required audits. They'll have policies, procedures, and training, which is great, except as you see by the picture here, there are lots of other things that are required. And by the way, one of the things we're hearing more and more in the industry is, do I need to be doing all of this? And the answer is yes. Okay, there is no such thing as HIPAA light. If you are not doing all of it, the government considers you negligent, and I'll talk about what those impacts are. For folks that are, let's say, hey, I'm small, or they're not going after my type of organization, do know that HIPAA compliance enforcement is up 400%. It is considered a revenue generator for the U.S. government, so it's not going away. And if the fines are and the reputational issues are not scary enough for you, do realize that people go to jail, licenses are taken away, as well as, your state attorney general has the right to enforce not just what we do consider federal HHS or OCR auditors. So you really have to be taking this seriously. I would argue not because of fines and it's the law, but because it's good business. And I'll talk more about why it's good business. So, a couple of basic definitions for folks that are not familiar, if HIPAA is a new thing to you. A covered entity, the HIPAA applies to what's called covered entities and business associates. So a covered entity is a medical facility, somebody who's involved with basically treatment, okay, doctors. And by the way, that can be a dentist, that can be a physical therapist, that can be an eye doctor, that can be a cardiac surgeon. Does not matter. You are involved in treating a patient in the U.S. healthcare system. Business associates, on the other hand, are vendors. Those are people that help a doctor do something in regards to healthcare. Usually what you see that is they are involved with, for example, let's say billing. IT or MSPs supporting IT, EHR providers, software providers. Often it can very well be your lawyer and your accountant, depending on what they're doing. It's anybody who comes in contact with protected or personal health information. Okay, so what is that? Protected information is anything, and it doesn't have to be. In today's world, we think that often people misunderstand, and they're thinking about the written. They're thinking about electronic stuff, right? They're thinking about their EHRs, and that's why Novastor is so important on the backup of your data. But in reality, this is written, oral, things on paper. These are screens that can be seen from people in waiting rooms. PHI is a little bit more than what people expect. Because often what we see is people will be like, oh, well, it wasn't PHI because it was just an identification number. Okay, it was their picture. It was just their telephone number. Understand there are 18 specific elements that are considered PHI, and the de-identification, which is the idea of, hey, it was not HIPAA information because we removed all the elements. Just removing everything but an account number is not considered you de-identifying PHI. Okay, so don't make the mistake that many people have made of, oh, well, we thought we cleared out the information. Okay, and as a matter of fact, there was an organization that was fined about $750,000. They were trying to recycle X-rays, and they used a firm to recycle it. They didn't realize, or they, let's say, were not quite as informed as they should be, that because they had given the X-rays to a destruction firm, that there was, in this case, account numbers on the X-rays, and that was considered a HIPAA violation. Okay. Now, by the way, for those as we talk about business associate agreements, all they would have had to have done to avoid the $750,000 fine is had a BA agreement in place. So let's talk about what those things look like. Big misunderstandings, or let's say the broad misunderstandings we see in HIPAA in the general healthcare community, whether you are a vendor, a BA, or a covered entity, a doctor's office, usually fall in these 4 categories. The first one being compliance versus security. Okay, as I mentioned earlier, PHI is not just the electronic data that you work with. HIPAA was written HIPAA's 20 years old. It was before the days of EHRs. So HIPAA, as far as compliance goes, is whether or not your organization is effectively, and I'll talk about what effective compliance is, being able to prove, because you got to be able to prove it, that did you do the minimum requirements that are asked for under the HIPAA law or the rules. okay? You can have a massive breach or incident, and as long as you can prove that you had an effective compliance program, you would not be fined. But even if you had the most minor of incidents or breaches, if you did not have an effective compliance program, you would be fined and could be very substantive depending on how you fall in the scale of negligence by the auditor. Security, on the other hand, is really a function of risk. And security, although there can be, HIPAA does get involved with physical security, locks on doors. Most of the time what people misunderstand is they're thinking of technology. They're thinking of, security risk assessments that have to do with, is there electronic information potentially vulnerable? Okay. Now, one thing about security is nobody is 100% secure. Security is about what I would call risk, i.e. you are doing your best to mitigate or lower the risk of something of your data being stolen or corrupted. Okay, but by all means, there is always a chance this could happen. And this is why, for example, why we work with folks like Novastore is having your backups is critical. Because if you do have your data get corrupted or stolen, the only hope is often that you had it backed up correctly so you could recover. Okay, so in the end, they intersect in many different places because in today's world, it is not, it is a much more diverse world than it was 20 years ago when HIPAA was first written. But I do think, when I talked earlier, that it's not just about satisfying the law. This is about the reputation of your firm, whether you are a doctor's office or a vendor. Understand that if it was, if it was written up in the local paper that you were breached or had an incident, that will look poorly upon you, right? That's going to negatively affect your organization. Okay, in spite of all the best efforts you did, you don't want to have that happen. That's what really, if you were to walk away from anything today, it's some very basic blocking and tackling. Doesn't have to be, substantive investments. Okay, can make a huge difference in your ability to prove that you did the right thing. Okay, so now the second misunderstanding we see is that most people don't understand that HIPAA is not one law. It is a set of rules. Okay, the three big rules that apply here that I want to talk about is the privacy rule, which really only applies to covered entities, to doctors' offices. And it's in regards to the way you communicate with your patients, right? You obviously don't want to have a sensitive discussion in a hallway, okay, where people could overhear. The area that we see the biggest misunderstandings is under the security rule, okay? And that when most people think of security rule, they think of what is a technology issue, risk assessments in regards to your systems, your IT systems. But in reality, the security rule really applies to three separate audits. Okay, there's actually 5 audits altogether, and I'll talk more about those in a minute. But security, or your technical audit, is the one that most people think of, and there's lots of different great ways to do that. There's lots of IT providers in the community that provide great security audits. This is also one of the big areas of misunderstanding, and that if you are a medical office and you are taking Medicare or Medicaid, meaningful use, which is a program of the electronification of health records in the United States, that is an incentive program, okay? That is not a law. You can choose not to participate in it, MACRA, MIPS, whichever language you want to use. But often people misunderstood, and that they thought that by doing that type of security risk assessment called for in meaningful use, that made them HIPAA compliant. Unfortunately, that is not the case. It is the case if you flip it around. Okay, if you were HIPAA compliant, which the law said you were, if you're a covered entity since 1986 was a law, you were supposed to 96. I'm sorry, you are supposed to be HIPAA compliant. Meaningful use on the other hand is 9 years old. Okay, so it was came in much later. Now, the next thing that has to do with a privacy audit, or also known as a physical audit, this is where people forget that, a big chunk of business today is still done in paper. Okay, so do you have screens, fax machines, file cabinets that are unsupervised? Is the language you will hear an auditor say. Okay, it's not how bulletproof you are. It is have you effectively proven that you are supervising the sensitive information you work with. Okay, the administrative audit is equally important, and that really has to do with, so you've assessed your risks as an organization, but many of your risks have to do with, do your people know what they should and should not be doing? So if you, it is in today's world, let's say with ransomware, although there is great technology, at the end of the day, the true vulnerability for you, or your first line of defense, is going to be, does your staff know what they should and should not do? Okay, so for example, if and this was there was an organization out of Minnesota that was fined $1.55 million. Okay, the mistake they made was that they had maintenance staff that had a facility on campus that they had never assessed that facility. Okay, so they did the clinics correctly, right? But they just never bothered to look at this remote building on their campus. The problem was maintenance staff would be working, and they had the ability to access. They were on the same network, and they were accessing information. In this case, they were accessing their personal email. Because it was on one network, they inadvertently downloaded a malware and brought the entire system down. So the fine was not for the breach. The fine was for not doing the administrative assessments of, do your policies and procedures adequately protect what's going on. Okay, the last rule is a very important rule. It changed recently in the end of 2013, and it's called the breach notification rule. And what it says is pretty straightforward. Any incident that occurs, whether you're a covered entity or a business associate, must be investigated. Depending on what the investigation bears, you either report immediately, i.e. within 60 days of identifying that there was an incident, or at the end of the year. Okay, so the meaningful, the reporting for within the 60 days is if it was a meaningful breach, i.e. that more than 500 people were affected. Okay, so now you got the rules. Let's talk about one more part of the rule. Okay, at the end of 2013, the omnibus rule was put into effect. It was an addition clarification to HIPAA. This is the thing that is probably affecting most people on this call today. Okay, and what it said was a couple of things. Basically, business associates or vendors had the same HIPAA requirements as the doctor's offices. And this was because, I'll talk a little bit more about where breaches occur and how they're identified, but roughly 30% of incidences or breaches come from the vendor, not from the doctor's office. Okay, so one is everyone's got to be HIPAA compliant that's involved with healthcare. Two, before, whether it's a covered entity or a business associate, before they can share information with each other, you must do two things. You must have what's called a business associate agreement. It's a legal document. Most people, it's funny, vendors often get, many people are afraid of BAAs. You should not be. A good business associate agreement limits the liabilities. It does not increase your liabilities. Okay. So for example, if you are, by the way, a vendor in the market, you need to be HIPAA compliant because you're in healthcare, not because your client asked you to sign a BA. The BA, on the other hand, all it should say is really, it may say many things, but it must say at a minimum, we both need to be HIPAA compliant. We recognize that. Two, I'm responsible for what I do. Three, you're responsible for what you do. And that's the simple guidance, although there's much more language in it. That's basically what it's saying. It's preventing people from pointing fingers at each other. And I will say very confidently, having been involved with hundreds of audits over the years with both federal, state, and OCR and CMS level, being able to clearly define where we began and end in our relationship is just good business. It makes it much easier for the auditors to say, hey, everyone did the right thing here, or you did the right thing, but your partner did not. Okay, so causes of HIPAA audits. A lot of people think that, I have to be a big hospital and either an employee or a patient saw something and reported me. That's not the case. There's really 5 different ways you get audited. Breaches, which is, okay, there was a breach or an incident, you had to report to the U.S. government, you're getting audited. Business associates, one of the changes in the rule is if your partner makes a mistake, when I say partner, I don't mean, let's say, partner in your business, but if your vendor causes a breach, in today's world, it is now the right of the government to audit all of that business associates' clients. Okay, and you saw this, for example, with the Clinical Works, $155 million fine for misrepresenting meaningful use attestations, things like that security risk assessment, and it is causing clients of theirs to be audited. Phase 2 random audits, hey, per the omnibus rule, basically the government can randomly pick you and audit you. Meaningful use failure, for those people who do attest for meaningful use, if you attest for meaningful use and there was currently a 79% failure rate, single biggest issue, they were satisfied meaningful use, but they did not satisfy being HIPAA compliant. Understand that although it is a separate entity, they reserve the right, if they think that you're negligent, to report you to OCR and be audited. The last is reported or whistleblower, okay? I do not have to be an employee. I do not have to be a patient, okay? I don't have to be a vendor. If I am walking by your building and I see you put a bunch of banker boxes with files outside, I can report you to the US government. I do it anonymously. And the real kicker here is under fraud, waste, and abuse, if money is recovered, not fines, but if money is recovered, it was proven there was fraud, waste, or abuse, I'm entitled to a percentage of it. So you want to be doing the right thing here, folks. How do you do the right thing? And that's where I want to spend, let's say, the more of time here. Okay, so this is a quick example. This was that orthopedic group I was talking about. If they had just had a business associate agreement in place, they would have saved themselves not only the $750,000 fine, but also they had to notify all 17,000 people that were affected. So it cost them millions to address this. Oftentimes you'll see in audits, you also end up with class action suits against you. So it is an ounce of prevention here goes a long way. So another little interesting one was this was a recent one, small pediatric practice. They were using an external storage group, i.e. Novastor is a great example of why it's so important to have strong partners that are fully HIPAA compliant. The organization was not HIPAA compliant. They did not do things correctly. Because of that, data was, in this case, it was physical information was lost. When it was identified, ultimately there was a $31,000 fine against the organization, not for the lost data, but for failing to have a business associate agreement in place with their partner. Okay, you'll notice that theme. For those of you who think that your technology partners are protecting you, most technology or most business associates have had at least one reported breach in the last 2 years, 59% of them, and many of them have had multiple ones in the last 2 years. So this belief that the misunderstanding that your EHR, your hosting service, your other partners that may be storing information for you are protecting you, that is not a safe assumption. You must be HIPAA compliant yourself. It has nothing to do with the technologies or partners you use. Overall breaches, 30% of them involve business associate. The point on this particular one here, the thing that is the most common issue for breaches or incidents is simple loss or theft of a piece of equipment, okay, or files. So in those cases, you need to be able to prove you had an effective compliance program, because if you can't, then it wasn't your fault that someone broke into your office and stole your computers. Okay, it is your fault if you can't prove that you had an effective compliance program, that if that stuff was stolen, for example, proper encryption, and why, for example, we're doing this, we're sponsored by Novastor today, that you had proper backups. Okay, so if you've not heard of Wall of Shame, for the doctors or covered entities, you do not want your name on this. Okay, it is any incident or breach in the United States is public record. So therefore, if you Google HHS Wall of Shame, you can look it up by state, by type of business, by covered entity, by BA, by physical name. People can see exactly who did what, right or wrong for that matter. It is a great thing for if you are a vendor in the market, if you're an MSP, for example, it's a great way to find out people who are having trouble, so you might be able to help them. Okay. Just little things that a lot of people don't realize. First fine of 2017 was $475,000. In this case, for failing to notify about a breach. Okay, so I'm trying to give you real world examples here of simple mistakes that could have been so easily defrayed if you had just followed the rules. Okay. By the way, if you have an incident or breach, you don't have to have the answer. You just have to tell the government that you identified it and you're working on it. That's what they need to hear. So don't be afraid. That if you have an incident, you don't try to cover it up. Just basically, let the government know that you had a problem and you're trying to fix it. That's what they want to see, intent, or in this case, malintent, when you didn't report. So you've heard me reflect several times here about effective compliance program. Often when I talk to people, they tell me that, Mark, this is so confusing. No matter how hard we try, how do we be HIPAA compliant, right? It's just such a confusing rule. Well, that's true, but also not so true. Okay. The challenge of HIPAA as a law was it was meant to address anybody in healthcare. So large doctors' offices, hospitals, small ODs in rural Tennessee or Kentucky. Okay. It also is meant to address technology providers, firms like my own, firms like Novastore. So what's effective is relative to what you do in healthcare. So the government, in an attempt to make this easy, said when an auditor comes and looks at you, I'm not going to ask you what level of firewall you have. I'm going to say, prove to me that you had an effective compliance program. There's 7 elements. And what those are, pretty straightforward. You can read them as I'm talking about them, but it's got to be in writing. Someone has to be the compliance officer. You have to have effective training, monitoring, lines of communication. The reason why I say effective, using that example of the Alaskan behavioral health, is what could have been perfectly effective for an office where there was no turnover was not effective in an office where there was high turnover. Okay, so you have to really think intelligently about this. Okay, disciplinary guidelines is, hey, listen, this is not, all the staff has to follow these rules, but the owners of the doctors don't. That's not the case. It's got to be, everyone has to have the same set of rules. And lastly, responding promptly to incidences or breaches, that's the breach notification rule. So if you look at yourself and your organization and you feel you can confidently prove these 7 items, you're in great shape. If you're looking at it saying, I'm not 100% sure, then here's the way I want to show you how to look at this. Okay, so to be HIPAA compliant, okay, these boil down to very tactical things. Okay, so the first off is you have to have done all of the correct assessments or audits. There's really 6 of them all together. They are roll up to technical, administrative, and privacy. So you have things like, hey, a true security risk assessment, asset and devices. You need to be doing all of them. If you're only doing some of them, you haven't really addressed or looked at how do you protect the information. Once you've done all 6 of them, the next thing you're going to have is gaps. This is where you deviate from the law. Okay. Now, to fix those gaps, you have to have a documented. Notice I said documented remediation plan. What does that mean? Hey, I have older XP computers. I need to upgrade them. Okay, I don't have a lock on one of the rooms, where my storage room, so I'm adding a physical lock. Or on the technical side, I did not have good data or my good backup or disaster recovery, so I've deployed a program like Novastore's. Okay. Actually, I think I even have that right there. All right. So now what we do see is about 15 to 20% of compliance really is technical in nature. It's a physical issue. Do you have backup? Do you have locks on doors? The rest of it, though, is going to be policies, procedures, and training. Okay. And they don't have to be crazy, written by your lawyers, although often if your legal counsel is a great place to start. But you do have to have the policies, procedures, and training that accurately reflect the way your organization runs. Now, one of the things about policies, procedures, and training is just checking off a box and saying you did a staff meeting is not enough, okay? The government requires that. Most of HIPAA is an annual requirement. You must do this every year, okay? So, for example, being able to prove that in this case, the term is document and version control, that you have your policies, and then on a regular basis, every year at a minimum, you've reviewed them and made sure they accurately reflect your practice, your business, or the laws that may or may not have changed. The next thing that happens is employee attestations. Okay, so it's not good enough to say, hey, everyone's been through this training. Okay, you need each one of your people to individually legally agree that they understood what you shared with them and that they're going to follow it. Okay. We had a situation where a client, one of their staff, blatant HIPAA violation, nurse access boyfriend's mother's medical records. The reason the client, clearly a big HIPAA violation, the reason the client was not fined was because they could prove they had an effective compliance program. In this case, they could prove that this staff member had legally, had signed off, okay, physically had agreed that they had read and understood that policy. So 3 months later, when they violated it, the organization could prove they'd done everything commercially reasonable to prevent it from happening. Okay, and those are the kind of tactical things. As much as I think, there are lots of great tools out there to do it, you can do this at home, folks. It's not, it was not meant to be hard. Okay, I'm not saying it's easy, but you want to simplify it as much as possible. So, next thing that's required under the law is business associate agreements. Every fine in 2016 levied, a component of it was failure to have BA agreements in place. It is not just the legal contract. You also must have what's called your technical due diligence. You are not verifying whether or not my firm is HIPAA compliant. You're asking for me to provide technical responses that I have enough methodology, technology, et cetera, in place to protect the information you're sharing. Okay. Last thing is you must have incident management. Okay. You have to be able to prove that you are allowing people to report incidences anonymously, by the way, that's the way the law is written, and that if there is an incident reported, that you have a definitive investigation process and then a plan on how to remediate them. So in summary, this is what an effective compliance program looks like. If you're doing this or you are roughly right in these categories, you're in good shape. If you're not, you really have to do a little bit of soul searching, look back at yourself and say, what do we need to do to have an effective compliance solution? So at this point, let me pass this over to the folks over at Novastore. All right, let me just do that. Hang on. So they can talk about the importance of storage in this particular equation.
All right.
Mike?
Thanks, Mark. Yeah, thanks, Mark. That was very informative. So just a short introduction. My role is Managing Director here at Novastore, where our claim is backup for the rest of us. That means that we understand that everyone's not an expert in our field and that most of them are overwhelmed and what we would call underfunded. So we break the mold by going the extra mile to provide you guidance through live local expert technicians to help ease your data protection burden. So Novastore is a company that manufactures data backup software, and we play a leading role in healthcare vertical, working to satisfy HIPAA requirements for well over a decade now. We approach HIPAA from all levels, working with Fortune 500 healthcare practice equipment solution providers, all the way through to just working with an individual healthcare practice. We ourselves have signed several BA agreements with our partners, so we fully understand what's at stake, and we're actually in this with you. So this is all great information that Mark has shared with me as well. So I guess this introduction slide to the backup portion, it says, are you backing up? It's interesting that we're positioning this introduction slide as a question. The reason for this, unfortunately, is that many of you aren't backing up, or at least not backing up properly. So the better questions may be, what is your backup plan, or are you backing up correctly? Our goal through this webinar series is to educate the market and get them compliant so we can lead with these types of questions in the future presentations. So let's get right into this. What is the role of backup with regards to HIPAA? Well, first I want to make this clear right off the top. Please be aware that backup alone does not make you HIPAA compliant. Backup is only a small but very important part of being compliant. Novastore can definitely help you in this area, but to attain full compliancy, you need to be communicating with experts like Mark at the Compliancy Group or with legal experts that specialize in HIPAA regulations. So to boil things down, HIPAA's data backup and disaster recovery specifications are all about ensuring the protection of protected health information, PHI, that Mark went over, which represents the personal health information of an individual patient. So I guess by definition, having a proper backup in place gives you protected health information, PPHI, but you can relax. I'm not going to create any new acronyms here. Also, it's important to note the rules for backup within HIPAA compliancy affect all covered entities, including business associates. So even if you're a service provider, and it doesn't matter if you're not healthcare specific, if you have at least one healthcare customer with PHI and host or manage data for that healthcare entity or practice, as a BA, you are just as at risk for penalties related for being non-compliant. So I think Mark's kind of laid into that fact a lot, and I just wanted to reiterate there. So now we look at backup's purpose in HIPAA, and well, under HIPAA laws, it provides a solution to cover three of the main areas. So there's confidentiality. That means that your information needs to be saved in a non-readable format, and there must not be any visible association to a specific individual or patient. Then there's integrity. The data must remain in the same format that it was originally saved. It has to be tamper-proof. Also, access to this data must be limited to only those qualified to view who are covered under those regulations. And then there's availability. PHI can't be lost, and it needs to be recoverable and usable within reasonable periods of time. So I know I covered, I stated that there was 3 issues here, but I've also decided to add one more purpose that is not documented directly in HIPAA regulations, but it even overlaps some of the others, but it's worth a separate mention. We're all very much aware, as Mark went over too, with regards to ransomware, especially in the healthcare industry, which is one of their targets. I'm sure that you all recall WannaCry. The wound's still pretty fresh for many. Statistics show that you have a 50% chance of being infected by a cyber threat or held for ransom. So backup is basically the only 100% effective solution for dealing with these threats. Because if you're a Novastor customer, even if you use one of our competing products, I encourage you to download the following checklist that we have here to link to help you look at the necessary steps to protect yourself from cyber threats. And I'm sorry it's a long link. We'll also provide this in a follow-up communication. So don't worry if you don't get it all here. But unfortunately, with HIPAA, it doesn't matter how or why you lost your data. Lost data is still a violation. So now that I covered some high-level topics regarding backup and HIPAA, I'm going to dive a little deeper into the details. So backup is not optional, although it appears that some still believe this from our experiences here. All CEs, including medical practices and BAs, must securely back up retrievable exact copies of electronic protected health information. This data must also be recoverable. This seems obvious, especially if you're backing up, as that's the purpose of backup. But the key here is that you must be able to fully restore any loss of data. Keyword here is restore. In our industry, we always talk about backup, but the only thing that really counts is your ability to restore when the chips are down. So without the ability to restore, a backup is rather useless. This goes back to the cyber threats, or what we unfortunately see way too often here at Novastor. We get approached by a reseller or practice to help with the recovery of their data, only to learn that even though they have a backup running, they were not doing the backups properly. So in some of the examples, they weren't selecting files, the proper files, or at least the right ones. They made changes to their environment without requesting support, or have overwritten previous backups in error. So these issues can really put you at risk. And even though they think they have a safe environment, they don't. So at Novastor and similar companies, we're the experts. Make sure you use this expertise. We do this stuff every day. This is only a tiny fraction of your responsibilities. So we understand if you don't know all the tricks. At the end of this webinar, I'll also provide more information regarding this, where you can get some more information and some help from our team. So you must also have a copy of your PHI off-site. There's some flexibility here with regards to what off-site is, but you need to have a copy of your critical data in a separate location than your practice. So off-site in many cases refers to cloud backup. This is maybe an ideal way to look at things, but can sometimes become also a sensitive budget topic. It can get quite expensive and time-consuming to move files, large amounts of files, into a cloud. Many practices also use local storage devices and removable tapes and drives, and physically carry a copy of their data off-site. This qualifies as off-site and is considered compliant. Although the more physical moving parts that you have, and it increases the complexity and could affect your data integrity and your ability to restore. So you also must back up your data frequently. In these days, even losing a day's worth of data would be considered significant. Make sure that when putting your backup plan in place, that you consider backing up your critical data at least daily, or even sometimes several times a day. You never know when a cyber threat or human error or a disgruntled employee could strike. So just never let your guard down there. Your PHI also needs to be encrypted, so while at rest and during transmission as well, so to prevent outside access. So make certain that your backups are encrypted with an industry-accepted encryption algorithm. AES today, I believe, is the industry standard. Also HIPAA, I think Mark stressed this so many times, HIPAA requires written procedures related to your backup data and recovery plan. So as long as you have something written, you can avoid penalty, even if data is lost. So work with a partner that can help you develop this documentation. And if you don't know how to do it yourself, then talk to someone like a Mark. So showing your intent and taking the time to document the protection of your PHI could protect you from penalties. I don't know, Mark, did you want to elaborate on that at all, or you're okay with that?
I'm okay with it, but it definitely goes. It's the basic blocking and tackling that you want to be doing. So don't take these steps. These are not arbitrary high level lofty goals. These are really what you need to be doing to run your business. So thank you all.
All right,
back to you.
Okay. Then I guess the next point is you must test your data recovery. So as discussed earlier, backup is useless if you can't restore. Unfortunately, testing and restore can be time consuming. So this step is often skipped or not done by several people. And I personally highly recommend testing as your backups, as it can protect you from potential penalty, and it's a required part of your HIPAA policy and procedure documentation requirements. So this is the NovaStore list based on our experience and research. Once again, I need to stress that these steps alone put you on the correct path for HIPAA compliance, but do not guarantee that you are compliant in all areas regarding PHI, because PHI expands well beyond just backup. So please do not take this as legal advice, but once again, talk to your experts like Mark, or consult qualified counsel for legal issues and compliancy laws. For HIPAA compliancy, you need a solution that can cover everything that we just went over on the last slide, but here are some other things that you may want to consider that makes your life a little easier. So backup is one of those things that works in the background and is often the victim of being out of sight and out of mind. Many times it only rears its head when something goes wrong, and that's only if you're lucky you get to get that warning. Sometimes it's too late by that point. So your ideal solution will also include a messaging system that keeps the important features of backup on your radar, like a tool that tracks success, or even more importantly, unsuccessful jobs, backup jobs, or has the ability to at least centrally monitor all your systems from a single screen. There are several providers out there to different healthcare entities that have several different installations, and it's great to have it all manageable from a single place. So just spending a few minutes each day can save plenty of time and money over the long run. On the topic of resources, I would also recommend working with your software vendor to determine your best backup strategy. Every business is different, and the software needs to adapt to your requirements to be effective. So some solutions require full backups every time that are out there. Do you have the time to wait for that, or do you have what we call the backup window to do this? Also with the cloud, like I talked about, there's budget and time sending files over. So being prepared, being prepared with your environment and having the right partner to help you set up your environment properly will significantly decrease any risk you have. A note here, copy is not a backup. So please understand that tools like Dropbox, which are cool, are just emailing files to yourself or drag and dropping files are not acceptable forms of backup. Using collaboration tools like Dropbox allow data to be compromised because they're collaboration tools. You can work on files, and to be HIPAA compliant, data has to remain in its original state. So also a copy is typically not encrypted and can be deleted or changed. Backup's a proprietary secure format. So files that are backed up are not meant to be changed. They should only be accessed if it's an emergency. So there are several ways that your data can become compromised, as disaster can present itself in several forms. It's best to identify these risks before they happen, or at least have a plan to deal with them if they do. So with that being said, here's a quick list of some of the hazards that are out there and what you need to do with your backup solution provider to help you prevent. HIPAA compliancy is the reason we're speaking today, but do not lose sight of the fact that HIPAA compliancy is not the real reason that you should be backing up your data in the first place. It's great to avoid penalty and be compliant, but it's even greater to keep your doors open. So with or without regulations, every business that plans to remain in business should invest in putting together a quality backup plan. Losing customer data or even your business data, like accounting information, can devastate your business. So nobody can afford downtime, or in the case if you're a service provider, a bad reputation. So basically, building a backup strategy is the next slide, and following the best practices. These are the type of questions you need to be asking yourselves. Once again, lean on your backup solution provider for help. But as you can see from this list of questions, like, what do you really need to back up, or how often are you backing up? These are all important things, and they need to be documented. These are questions that we can help you answer, and basically make sure that you are as HIPAA compliant as can be. So basically that's pretty much the last slide on backup, and we're going to be offering a tool a little later that will basically give you a checklist of what you can do with regards to backup and HIPAA compliancy, and I think we'll be showing that on a slide at the end here. This basically backs up the backup portion of the presentation. And at this point, I'm going to be handing the control back to Mark. So Mark, you can take it home here.
Thank you. Let me just there we go. Okay. Ooh, hang on, let me make sure we're showing the right screen there. Sorry, folks. Got all the background. Okay, so if you have questions, you are welcome to, there's a bunch of questions. I see them posted. Give me 1 second. If you would like, you are welcome to hit up Mike or myself or our respective firms with contact information. Let me, so please do, and you'll find that both of us are more than willing to answer questions. They don't have to be because you're buying our software or our tools, but please, obviously, we'd love to, if you are interested, give us a shout. One of the things, as we were talking about, there is lots of great resources that are available. There are checklists that both organizations have, as well as a lot of free resources that we have on our site. Okay, so let me just kind of back up here and go back. I'm going to leave this up for a little bit. Let me start taking some questions. So let's start off with, okay. Mike, this is going to be to you. One of the backup schemes is an NAS with encryption. Let's pretend the NAS is stolen. How do you prove it was encrypted?
Okay, well, actually, with our backup software, that's what I can mainly speak about here, is that there's two types of encryption. There's hardware encryption and there's software encryption, and we have it as default on our system to encrypt files with the AES at least 128 or 256-bit level encryption, and that's a setting that's automatically set. So you would have to uncheck that encryption setting on your backup software to basically not be protected, but you should always check and make sure that you are protected there. But so if you're using our technology, at least if you are backing up data and you are backing up data with our software, it will be encrypted, and you can actually point to your log files, and the log files themselves that show when you have a successful backup, and that it'll show that the files are encrypted. So you will show that you've at least taken the right steps to protect the information.
All right, a question that's been asked a couple of times here, folks. I'm just going to answer this. This webinar this recording will be available. It will be up both on the Novastar website, as well as if you go to Compliance Group to our /webinars page, you can download this as well as many other resources that are available to you. But okay, so the next one is there a testing time requirement, i.e. monthly, quarterly, or annually?
Okay, for the testing time requirement for backup, within the backup software itself, there is a verify feature. So you can at least verify that your backups were successful. There's no specific set rule, but we do recommend that you're testing your backups on a regular basis. So minimally quarterly, ideally monthly, but the key thing is just to make sure that you can recover information. You do have to do that. We have what we call full and incremental backups, and just making sure that all the backup is captured each time, and doing the restore, sometimes even spot restores of specific files, just things to back up the verification that's already provided within the software itself.
Okay. Next one came up is if we lose data, we just go to paper, ? Heard that a bunch. Thoughts on a practice going to paper if systems are down? All right, so it sounds kind of more like for my part of the world. The issue here in disaster recovery or business continuity planning, okay, for your organization, you should be thinking about not just, as Novastar is pointing out, that if you have backup and they're off-site, et cetera, but just something as simple as your internet being down. okay? Depending on how you're structured, you should have a continuity plan. So disaster recovery is the building burns down, what do you do? But if you just have a power outage, your internet is out, phones are down, you should have a backup plan as to how you're going to provide the service. Now, if you're a covered entity, going to paper is perfectly fine. You know, for many years, and there are still many medical practices that paper is an integral part of the way they provide service to their patients. So there's nothing wrong with it. You know, the push to electronic health records was really driven by the importance of being able to share information more efficiently, i.e., I'm seeing one doctor for one set of symptoms. I want to be able to share my medication that I'm taking so that you don't end up with conflicting medicine. Okay, so there's nothing wrong with paper. Paper is a great backup. Believe it or not, you know, things like faxing are still considered a HIPAA compliant, secure messaging approach. Okay, so for all the technology that we talk about, the issue here and the thing to go back to is supervising of data. So it's okay to have paper, but you should also have, is it being supervised, file cabinets in either, let's say, a room where the door can be locked, or maybe the file cabinet needs to be locked. Those are all very, very, you know, absolutely HIPAA compliant, appropriate ways for you to run your business. So, okay, so the next question was, can you share a list of controls that match with HIPAA compliance, that match with backup? So, Mike, I don't know if you want to, you want to take that one?
It's a little cryptic for me. I'm trying to understand that as far as.
Yeah, I'm trying to think of, yeah, please, do you want to take a shot and then I'll add to it, or we can both take a shot at it?
I mean, I kind of went over the list of like some of the steps that you need to make sure on one of the slides there, which you said it's been recorded, and that was having a copy off-site, backing up frequently, having encrypted backup, different things like that. Those are controls that you have in place to, and also, as we discussed on previous questions, verification and testing and things like that. So those are controls you can put in place. I'm just not sure if I'm doing that question any justice with my answer here.
No, and I think it's
but one thing I can say,
yeah, please.
Well, one thing I can say is that with that link that we provided for further information, there are people who are much smarter than me here at Novastore, and they can actually ask the questions to our technical people, whether they're customers or not. They can reach out to us and maybe say that they attended this webinar, and we can have them talk to technical people and maybe go in more detail and have a full conversation to get a full understanding of that question.
All right. And you know, for the person who asked, we'll try to get back to you with some more complete answers. As far as I was talking before about an effective compliance program, the government didn't mandate that you must do it a specific way. Okay, what they mandated is you have to prove that you have an effective solution in place. Okay, so some of that has to do with the business you're in, i.e., if you're a EHR, your backup needs to be much more diligent than if you are a solo practitioner, you know, seeing a couple of patients a day. Okay, so do, you know, some of this has to, you know, match up logically to what you're doing. Okay, let me go next question. Okay, so our current IT staff performs the security assessment and we back up daily to tape. What are your thoughts, responses? So let me start, Mike, and then I'll pass it off to you. First of all, remember, being HIPAA compliant is not your security assessment. That is one of 6 required audits. It has a lot to do with, it is much more to do with your overall management of your organization. So having an IT group do a security risk assessment is a fantastic and very critical component, but you really have to be doing the rest. Okay. Now, Mike, I don't know if you want to talk about backing up to tape and thoughts on that.
Yeah, okay. Well, and generally, just for a good backup principle and also for HIPAA compliancy, this rule really helps. And in the backup industry, it's known as the 3-2-1 rule. And that's basically having 3 copies of your data on at least 2 separate devices. And one of the copies has to be offsite. As I mentioned earlier, offsite could mean cloud, or it could mean stored offsite physically. So if you're doing the weekly or the daily tape backups, first of all, the first question is, are you setting the encryption on the tape? But make sure that the data is encrypted on the tape, because even during transmission, even if you're putting it into a secure site physically, it still can't be compromised. And also, basically, and also you got to understand where the tapes are stored. They have to be in a safe place and off-site from the actual office location.
All right, so thank you. The next question is, must EPI at rest be encrypted? Okay, so this opens up a really interesting set of points. Okay, so yes, absolutely. Whether you are large, medium, or small, having your data encrypted at rest and having correct backup and storage are the two most critical things that we advise people. Okay, the reason being, if you had a meaningful breach or ransomware or whatever, someone stole the computers, it doesn't matter. If you were truly had your backups or even your live data fully encrypted at rest, what happens is whatever they have stolen from you is of no value. They can't read it. Okay. Now, why is that important? That's important for two things. One, the information is not compromised. Okay. If you've done this correctly, you are fortunate. You have Novastore. You pull your uncorrupted backup back up, and now you're ready to go again. The second reason why this is so critical, and thank you for asking the question, is if you can prove, right, you have an effective compliance program, and that your data was properly backed up, and it was fully encrypted, in this case, encrypted at rest, then there is no violation. Okay, there was no breach. Why? Because the data was never accessed. Okay, so you don't have to report it to the U.S. government. Okay, because you did not have a meaningful breach or incident. Basically, someone stole, it's the equivalent, they stole your coffee maker. Okay, they can go make coffee somewhere, but it has nothing to do with your data. And that is why the issue of the combination of, being HIPAA compliant and all the things that you saw that are required, but, two of the best pieces of advice we can give you is encrypt properly and back this stuff up. Because if you are encrypted, there's no breach, and if you backed up correctly, then you can fully restore and come back to be back in business, in a very effectively and a very cost-effective fashion. So the two are very critical.
And Mark, I think
please go ahead.
Hey, Mark, I think what you mentioned earlier, like you backing up correctly, is obviously key to getting your business back up as well. But even if they back up improperly or whatever, as long as they have it documented, as you mentioned, is the key. Because even if they can't recover that data, which is a situation nobody wants, but as long as it has been documented, it still escapes being a breach. Is that correct?
Yeah, no, absolutely. The issue of proving that you had an effective compliance program, absolutely. Documentation, supporting information, proof that you had the right intent. At the end of the day, though, as we all here are, whether we're serving patients or serving clients, being able to bring your business back online is critical, right? Because obviously it's how you serve your clients. So it is having good documentation is critical for what is satisfying the law. And then having good backup like Novastore is critical for helping you protect your business, right? So we recommend both. I'm going to take one last question, and then we're coming up on the hour. The other question we see that I'm seeing here, and I've seen a couple different iterations of this, and that is business associate agreements. Okay, understand it is a requirement before you do business with someone about whether or not you have a BA agreement in place. Okay, so if you are a covered entity before you outsource to somebody, all right, like the Novastore, you want them to execute a BA agreement with you, and they would. Okay. On the same token, if you do encounter a vendor who does not want to sign a BA, who does not want to supply the necessary information for a technical due diligence, mince no words, find another vendor. Okay, because the person who gets fined, and the smallest fine we've seen for a BA agreement was $300,000, is you don't want to be that person, right? That's a very painful lesson learned. Okay, so we highly recommend that you if you are dealing with BAs or vendors, if they are unwilling or if they're confused about their requirements under HIPAA, find a vendor who's got it down. Okay, because this is, as I said earlier, 30% of the breaches are caused by your partner or by your business associate, and it can absolutely get you into a lot of both financial and reputational issues. All right, so we are up on the hour. Folks, if there's more questions, feel free to email them to Mike or all. I'm going to put that back up again for a second. We do appreciate you taking the time to join us today. This will be available as a recording, so if you want to share it with other folks, you are welcome to. The resources, both free resources from both Novastore and Compliance Group, are available to you if you'd like to, download them, review them, and obviously both organizations would love to talk to you about how we can help you with your organization. So, Mike, thank you so much. The attendees, thank you so much, and have a great day, everybody.
Thanks.
Bye-bye.